All right, it's 10 o'clock on the dot, so let's go ahead and get started. I see some familiar faces, so I think some of you must be gluttons for punishment if you attended previous WTF classes, especially last July and August with me. God love you. You're the unsung heroes of this endeavor. So there has probably been a little bit of confusion if you've been watching any of the pages lately. So I had to do a brief renaming of this session. PAR was issued a cease and desist by NAR regarding the name and the attributes of MLS Choice. So what we are going to discuss today is still probably going to be referenced as MLS Choice, but it's not. For my Prince fans in the audience, this is the program formerly known as the MLS Choice Purchase Contract. It is now non-member MLS Access Purchase Contract. Just what we all needed, right? More confusion to add to the layer of nuts that's going on. So a few things to get started. Some ground rules. Please keep yourself on mute unless you are asking a question. Please ask questions out loud so I don't have to monitor the chat box. If you do type something into the chat box, I will review it later after class and I'll respond to you individually if I know what it is that you're actually asking. I suspect we will have some stragglers who come to class late. So for my folks who are already on, one, thank you for being prompt. Two, if you see somebody type a question into the chat box, would you kindly remind them like, hey, she asked everybody to ask them out loud. So unmute yourself to ask so we can get through this. Don't worry about taking screenshots. This entire slide deck and a link to the class recording will go out to anybody who registered for class today. So you don't have to worry about trying to manage all of that. And if you haven't already done so, or if you're not aware, you can find copies of all of the non-member MLS access forms at the phoenixrealtors.com website. There is a designated area and there's only 8 of them, so it won't take very long to get through. Today, we're only going to go through the purchase contract, but at least you'll know where you can find the others in case you encounter them along the way. I'm going to get started with just kind of a brief poll. I want to explain that this class is not going to be an in-depth, line-by-line contract analysis for the non-member MLS access purchase contract. Really, this is just to serve as an overview of some of the differences, the critical differences perhaps, between the AAR purchase contract and the non-member. I'm just going to bear with me. I'm just going to call it the non-member purchase contract. Are we cool with that? So I don't have to keep reiterating the same long name. So the AAR purchase contract versus the non-member purchase contract. We're going to point out some of the differences.
I'm so sorry. Can you repeat that? Repeat that one more time.
Yeah, we're going to go through the AAR differences to this contract, which is the highlight of today, which is the non-member purchase contract. Judge, you probably won't have to worry so much about this because you didn't learn one way already. So you're just going to know it straight from the get-go here. So this
is from the MLS choice, right?
Correct. Well, it used to be MLS choice. Now it's non-member MLS access.
Got it. Thank you.
You're welcome. All right, so let's go ahead, understanding kind of the lay of the land here today. Let's go ahead and get started with our first poll, which now I have to reintroduce this. Come on. All right, so just a few things for poll number 1. Can you all see the poll on the screen? True or false, if we are a realtor and receive an offer for our listing on the non-member MLS access contract, we must present it to our sellers. Number 2, true or false, if I am a realtor and I receive an offer on a non-member MLS access contract, the best practice is to use the AAR purchase contract to counter. 3, true or false, both AAR and non-member MLS access forms are considered standard for the purposes of legal use and E&O coverage. And number 4, on the AAR purchase contract, when is earnest money due from buyer? So we went kind of very broad scope into something specific. So go ahead, take just a couple minutes here to get these questions answered. All right, last 5 seconds. All right, let's see what we got here. So true or false, if we are a realtor and receive an offer for our listing on the non-member MLS access contract, we must present it to our sellers. That is true. You must present any and all offers to your sellers unless you have written instructions to the contrary, but I don't recommend that. True or false, if I am a realtor and I receive an offer on a non-member MLS access contract, the best practice is to use the AAR purchase contract to counter. So most of you answered true, a fair number answered false. I think that this has been mistaught on many levels, both from instructors and from comments that I've seen in some of the Facebook forum pages. I will never agree that countering with a full and different contract is the best way to address a counteroffer. In many cases, that's simply going to be a reiteration of terms, which is not the purpose of a counter. And ultimately, I'm not convinced that the average agent knows as much about the AAR purchase contract as they think they know. And ultimately, countering back on that in some cases may be a disservice to our seller when some of the things, as we will discuss today, in the non-member contract are actually more to their benefit. So what it boils down to is whether you're a realtor or you're not, you need to know both of these forms adequately enough to summarize and explain them to your sellers and buyers, of course, so that they can respond accordingly. And I'm actually going to give you some very specific counter language that you may or may not want to make part of your standard review process with your sellers if they were to receive one of these.
Leah, can you hear me?
Yes. Yes, I can.
Can we just use the counter offer one form?
Yes, exactly. And that's what you should do. There were a lot, and I do mean a lot of comments and instructors indicating, hey, why not just counter back using, in essence, the entire 10-page AAR purchase contract as the counter? I think that's silly. I would argue that I think there's a lot of other issues with doing that as well. But so yes, standard counter form. And there's actually a counter form for non-members as part of your non-member documents. And of course, the AAR standard counter offer. So depending on which side you have, those would be the appropriate forms that you're using. On that, maybe you all know this, but just to make sure that this is clear, you are using whichever forms are available to you. So if you are a realtor and you are submitting an offer on the AAR purchase contract to a listing that is listed with a non-member, they will counter you on the non-member form. Okay, similarly, if you are a realtor and you have a listing and you receive a non-member purchase contract on your listing, you will counter with the AAR counter form. So whatever documents you have access to, those are the documents that you are using. So there will be crossover between these documents.
Okay, I interpreted that question to mean that you would use the counter one form. I didn't interpret it to mean all 10 pages.
Oh yeah, no. So that was your countering using the entire 10-page purchase contract. And several people have recommended doing that. I'm not one of them. Talk to your brokers, see what they want to do. So Lynn, you have my answer.
Leah, can you hear me?
I can, go ahead.
You said something about it may work in the benefit to use the non-MLS form or counter, but as a realtor, are we able to use either?
No. So you can only, yeah. So what I mean is you don't want to use the 10-page purchase contract to counter an offer from a non-member, because there are parts of that purchase contract for AAR that, I'm sorry, for the non-member that I think are actually beneficial to our seller. So why would you counter back adding things that aren't beneficial to them?
Okay.
But that's what we're going to go into today, Mitch. So you'll get a feel for what I'm talking about when we discuss some of the specific terms.
Gotcha.
True or false? Both AAR and non-member MLS access forms are. Oh, Gladys.
Oh, I'm sorry. No.
Mute
I'm
yourself,
just
woman.
having technical difficulties over here. Sorry.
All right, both AAR and non-member MLS access forms are considered standard for the purposes of legal use and E&O coverage. This is true to the best of my knowledge. I've chatted with several brokers, and I have not heard of a single E&O carrier that would consider them anything but. So for the arguments about these aren't standard forms and if I'm a realtor, I don't want to use them or engage with them, that it's simply not true. You are covered, so you don't have to worry about it from that standpoint. And then let's get some technical stuff. On the AAR purchase contract, when is earnest money due from buyer? Okay, within 1 business day, and none of the above were the 2 most common. All right, I need somebody to be brave. Someone who marked none of the above. Tell me what the contract says. When is the earnest money due?
I totally forgot. I didn't even answer number 4. But I thought that earnest money is just kind of like you're just kind of giving it to them, so it's not really necessary.
Nope. It's definitely necessary. So it's consideration for the contract and it's part of the contract terms. But for this one, this is actually specifically regarding timing. And I phrased this in such a way because there is a unique timing aspect to this. There's one which is the court interpretation and how case law has upheld it. But then there's the actual black and white of the contract. So for someone who marked none of the above, I'm curious, why is it none of the above? What is the actual timeline that's referenced on the purchase contract?
Well, doesn't it say as soon as the contract is executed?
Yes.
Yeah, pretty
That's
darn
the
close.
wording.
Yeah, so
Yeah.
upon acceptance. Okay, so
Yeah.
that's kind of vague and ambiguous, right? So upon acceptance, but what does that actually mean? So the case law interpretation has been within 1 business day, that the next business day is when the buyer would deposit earnest money. But that's not what the contract actually says. So you can see where that's a little ambiguous. I bring that up because that's actually one of the key changes on the non-member contract, and just something that I think was actually a positive change. So let's go ahead and let's get into the first couple of pages here. So for those of you who haven't seen this yet, this is the non-member residential resale purchase contract. The top few sections here, I think, are pretty easily understood. It's fill in the blank. So your names, your addresses, go ahead and ask me, oh, do I have to include the mailing address and the contact information and the email and the phone number for the buyer or seller on here? We have these lines on our existing AAR purchase contract. Whether you fill them in or not is probably discretionary. I will say that the reason that they exist on here is actually because you're supplying instructions to the title company, and this is very handy for them to have this. But I also understand that many of our clients probably don't want, and we don't want, the other party to have our client's contact information. That sounds like a bad idea. So for those who can see my shirt, hashtag what would Leah do? Leah would actually leave some of those. I wouldn't include an email address or a phone number. I would leave those blank, but when I send over an executed contract to the title company and the lender, obviously the lender should already have it, but the title company for sure, I would make sure that I include my client's contact information in that private email to the title company. So not on the contract, but going ahead and letting the title company know how to reach them because they will need to. Then the real estate agent information, I do like, as opposed to having to mark the little boxes on 450 and 464 that are still confusing to agents no matter how long they've been doing this. Those indicate, hey, who do you represent? Seller, buyer, or both? And more often than not, this is overlooked or improperly marked. So this one I think is pretty simple. If applicable, you're going to mark the dual agent box. Now remember, dual agent means you personally representing both parties, or you and any other agent under your designated broker representing the parties. So even if there's 2 agents listed here, if the designated broker is the same, then you would need to mark that dual agent box. Property information, again, all of the typical stuff that you would need. 26 is different. So this contract is going to be used for both residential and vacant land. AAR has 2 separate contracts for those, but these are merged for non-member forms. So just make sure that you are marking the appropriate box for what type of transaction this is. Questions on the first half of page 1? I see stuff coming into the chat. Remember to unmute yourselves and ask. Oh, is it? Uh-oh. Sorry, Sherry. Hopefully you know what I'm talking about as I go. Yeah. I think I got this on Etsy, Leah.
So as you're Leah, as you're moving down, there it goes. Now it's moving. When you were talking about what line, I was still up from the 1 to 26.
Oh, okay. So, but it's moving for you now.
I didn't move it. Someone moved it for me.
Yeah, no, I'm the controller. So
Okay.
can you see you can see the bottom where it says initials for buyer and seller?
I can. Thank you so
Okay,
much.
excellent. Well, I was freaking out for a minute because I'm going to go off topic. I apologize, people. I opened my computer this morning, which is a laptop, but it's a detachable tablet laptop, and my screen is upside down. Now, I can't rotate the screen like physically because the camera is only on top. So you'd be looking up my nose the entire time. And I was getting so irritated trying to figure out what setting did I possibly hit that rotated my screen. And I know the typical Control Alt functions, that wasn't working. So I had to go some crazy way to try to figure this out. So the moral of the story is I'm glad I'm not having to look at all of you upside down and read a contract upside down. But Sherry, I'm also glad that this is officially working so you can see what I'm talking about. All right, so we're still on page 1, and this is the purchase price breakdown. So again, all of this should look very similar. Your purchase price, your earnest money, your down payment that's due, your balance due at close of escrow, and is it cash or is it going to be other? Other obviously would be a loan, and that's what's going to be discussed in those other sections. And then right here, boom, seller concessions and seller compensation. Like the seller concessions right now take up a couple of lines, 100, 101 in the AAR purchase contract, but it's just here, very similar language. It's not going to alter anything. I actually like this part. So the seller compensation, it's not even a totally separate form. It's just right here. You don't have to add anything. You just mark the box if you as the buyer's agent are asking, or I should say, if the buyer is asking the seller to pay their buyer's agent, you would just need to mark that little box and indicate what percentage or dollar amount you're doing right there. But go up to this highlighted section under earnest money. Specific, deposited into escrow account within 2 business days. So none of this case law interpretation, none of this, upon contract acceptance, where it's a somewhat vague term, within 2 business days. So you know exactly when you can cure and there's no argument over it. So this is point 1 for the non-member contract because I like that they have indicated a specified time period. Going down to additional addenda incorporated. You may recall from when I first showed that screen, again, there's only 8 documents. Really the only addenda would be the on-site wastewater treatment facility, which is in combination with the well addendum. Good, bad, or otherwise, it's all on one form now. There is not a buyer contingency addendum available to non-members, nor is there a lead-based paint addendum available to non-members. Don't freak out. For those of you who have been with me for a minute, you know I hate our buyer contingency addendum, and I think that there are better ways to handle that, which we will cover. But the lead-based paint, it's actually going to go into the next page. I'll have another poll before then, but into the next page, it will tell you exactly where you're going. So the lead-based paint disclosure and an addendum, so to speak, it's not an AAR form. You can actually get that directly through the website and handle it that way. So it's not like you're missing out on necessary documents. Tammy, did you have a question?
Yeah, sorry, Lee, I didn't want to interrupt.
You're
I have
fine.
a question about the seller compensation. So when we're uploading for our broker, they're requiring that SCA. So if we're not getting one from them, are we having to counter just on a counter or do an SCA on our end if we're using the other forms? I'm just a little confused as to what happens with that SCA.
Yeah, so you won't have one. So in a case like this, an SCA doesn't exist because it's not an addendum that would be incorporated into this contract. So if this is the contract that is being uploaded into your SkySlope or whatever your management solution is, you should not be flagged for an SCA. Now, that being said, obviously this is new to all of us, right? So bear with us as we try to navigate this and figure it out. If you are flagged, let your broker know, because that's not an appropriate document to use in this situation.
Thank
Even
you.
if you counter, I wouldn't counter with an SCA, just counter with that percentage or dollar amount that you're countering with on a standard counter form.
Okay, thank you.
You're welcome. Any other questions about that part so far? Okay. Poll number 2. Only a couple here. According to the AAR purchase contract, in the case of an earnest money dispute, who determines the disbursement of earnest funds? And the second one, if HOA information is missing or incorrect on page 1 of the AAR HOA addendum, who is responsible for those missing or incorrect fees? So go ahead and respond to those 2. Five seconds. All right, let's see what we've got. Okay, so according to the AAR purchase contract, in the case of an earnest money dispute, who determines the disbursement of earnest funds? The escrow or title company. Yes, for the contract, that is exactly right. Some of you are on board with how I operate. I'm like, the agent who fights the hardest very often is going to be the winner of that dispute. And really, it's not even who fights the hardest, it's who's the most knowledgeable and can pull out all of these weird, wonky interpretations of the contract, different case law references. If you go to Legal Hotline and you pull up their articles, those are oftentimes what's winning the earnest money. But for the contract, it is the title/escrow company who's responsible for the disbursement in their sole discretion. If HOA information is missing or incorrect on page 1 of the AAR HOA addendum, who is responsible for those missing or incorrect fees? As marked on line 75 of the HOA addendum, that is correct. So on the HOA addendum, the AAR HOA addendum on page 3, line 75, has a clause specific to that, in essence indicating for any undisclosed or incorrect fees, who is going to be responsible for payment. 9 times out of 10, obviously, it's the buyer filling that out, so they're going to mark that the seller is responsible. I've posted that here specifically because you're going to see a slight change to that. So a couple of things. Again, close of escrow information, it explains it occurs when the deed is recorded at the county recorder's office. When possession is going to occur, time is of the essence, what they're being, the delivery and what they're getting at close of escrow. But what I love is where it says close of escrow date, and then it says in parentheses, must be a specific date. I see so many contracts that still use on or before. No matter how many times brokers and AAR have instructed you not to use on or before, agents still do it. So I like that this is highlighting the fact that, hey, you can't put on or before here or any vague terms. It needs to be a specific date. And then they go into the title and escrow company information. Again, contact information, what the escrow company's responsibilities are. There's no changes there. But one of the biggest changes in this contract is this highlighted section 66 through 72. In the event of breach by a party, the escrow company will not release earnest money without first receiving either an earnest money distribution agreement signed by all parties or a judgment from a court. In such event, if the parties cannot come to an agreement on how the earnest money shall be distributed, Section S, mediation, which we'll cover, shall apply. If the parties cannot reach a resolution through mediation and proceed to litigation, at the conclusion of litigation, the court will issue a judgment apportioning earnest money. The escrow company holding the earnest money has the option of filing an interpleader action, which will force buyer and seller into litigation. Alternatively, the parties may sign an agreement for broker or legal counsel to hold the disputed funds in their trust account until the litigation is resolved. I have mixed feelings about this. So I actually sat in on a class with the author of this contract. It's Jessie Wolnick. She previously worked on AAR's legal hotline. Obviously, she's a real estate attorney. She's been a broker in Arizona for many years. And I understand where this came from. Part of it is the thought process that ultimately it's not up to the title and escrow company to interpret our real estate contracts. Fine, that's fair enough. The second part was that in many, especially now, in many cases where there is a dispute, the title companies are directing the parties to go this route anyway. I personally have not had that experience. There have been a couple that held and they either escalated it to a higher level of their upper management or their own legal team within the title companies. Or they did say, hey, you're going to have to figure this out and come back to us and once you have an agreement, we'll determine how we're going to disperse. I understand that those things can happen. What concerns me about this clause here, as opposed to allowing title and escrow to handle it, is I don't want the party who, quite frankly, shouldn't be entitled to earnest money, and I think it's a pretty black and white, they shouldn't be entitled to earnest money. I don't want them to be able to, in essence, hold the earnest money up on behalf of the buyer just because they're going to force action. They may not even ever enter litigation, but do you know how long it takes to get to that point? So if they really wanted to be asses about it, they could prolong the return of the earnest money with really no grounds to do so. So of all of the changes, quite frankly, this one I like the least. This is one where if I am a Realtor member, and quite honestly, guys, even if you're non-members, it might be something you want to consider, that I would counter this back. And I would include the verbiage, in essence, that's already in our AAR purchase contract regarding that title and escrow is going to be able to disperse in the case of a dispute at their sole discretion. Questions about that?
So that would be countered in every contract.
So only if you receive those. So let's talk reality for a second, because I think that's a great point, Lynn. I don't know how many agents moved over to the non-member MLS access option. I can tell you from my office, there were fewer than 10 out of 470 of you. So I don't know that this is going to be the overwhelming, like I don't know that you're going to get a ton of these contracts. You just have to be prepared for them when they come in. So obviously, if everybody's using an AAR contract, we're totally good. So it would only be in that rare case where an AAR member is getting an offer from a non-member. But like I said, even those non-members who were previously realtors, they may understand the benefit to modifying some of these clauses as well. Clear as mud. All right, we're good. Moving on. Title closing fees, costs. Notice I have nothing highlighted here. For the most part, this is all going to be identical, if not similar enough that it wouldn't change anything on the terms of the contract, except for one little section. So we don't have an HOA addendum. Okay, the HOA fees are all addressed right here in the contract. So the primary difference here is that the buyer is originating this contract. With the HOA addendum, if it's best practice, the seller is actually filling out page 1 of the HOA addendum and then uploading that to the MLS or sharing that with prospective buyers. And then page 3 is completed by the buyer. So what this means is you're not going to have the information on a separate document up front, meaning if you're a non-member when you submit this. So you're going to rely pretty exclusively on the information that is provided in the MLS. What this doesn't cover, and again, whether it's in the MLS, whether it's on a separate page, I don't know that that's a huge deal in my opinion. You can get the information and the buyer can always call the HOA company for verification. Where this doesn't have something that I think it should is who pays the fees, and in this case, they would be potentially disclosed or not disclosed in the MLS. Now, if you are a non-member, you're submitting this offer, you have the information in the MLS, which may include the HOA addendum. I know this is starting to get a little into the weeds, but you can't use that HOA addendum in the MLS because that's an AAR form. So even if it's in there, you as a non-member would not be able to use it. So you can only handle the negotiating of those fees right here. And it doesn't specify who pays the fees that were not previously disclosed. So that might be something that you would want to add into your additional terms, just to make sure that that's covered. Now, if you are a realtor submitting an offer, if you could still use the AAR addendum in that case, but that means now you are going to be filling in, which I think most of you are doing this anyway, you're going to be filling in page 1 of that HOA addendum, and then you're going to be submitting all of page 1 and page 3 for the seller to review and sign as part of the offer if it's a non-member. Okay, any questions before we move to the third poll? Okay. Two questions on this one. On the AAR purchase contract, when does a buyer need to notify the seller of any changes to their lender or loan? And also on the AAR purchase contract, where does the buyer disclose if their down payment or other funds needed to close, like closing costs, come from a gift, third party, or otherwise non-liquid account? So go ahead and answer those. All right, let's see what we got here. So on the AAR purchase contract, when does a buyer need to notify the seller of any changes to their lender and loan? The majority of you responded immediately, and that is correct. You have to deliver notice of such changes. Some of you may have confused this with, in essence, you need permission or you need an addendum for those changes. That you do not need, so long as it does not adversely affect the seller. So closing date, cost, et cetera, on behalf of the seller. So immediately is the right response. For AAR, you have a notice disclosure form that you can use for this purpose. But quite honestly, prior to that document, even an email was sufficient. So both of those would serve appropriately. On the AAR purchase contract, where does the buyer disclose if their down payment comes from a gift, third party, or otherwise non-liquid account? On the pre-qual LSU and the additional terms of the PC, this does not need to be disclosed. Interesting. Interesting. So I will tell you that very, very rarely does the pre-qual specify where funds are coming from. It says that they've been verified, they have them, but very rarely have I seen it actually specify, oh, this is coming from a retirement account. This is coming from, some lenders are really good. They'll indicate, hey, we're getting gifted funds from so-and-so. This is coming from a stock account, things of that sort. We don't get that information. They just indicate that in essence, they've verified assets. So realistically, this is a contingency. This means that the buyer's performance ability on this contract is based upon them successfully obtaining funds from an account that they do not have immediate liquid access to. Even retirement accounts, even if it's something like a 401k loan that they can take out, the problem is there's timing associated with that, and sometimes there's parameters associated with that. So if they are getting funds from something that is not their savings or checking account for the most part, that needs to be divulged in the additional terms of the PC. That would need to be shared that, hey, this is contingent upon them getting funds from this source. So as part of that, this continued the association information. That's just the general info that's on page 2 of our existing AAR HOA addendum. So nothing new there, just a reiteration. New loan with financial institution or private lender. So this is the yes or no. If it's no, then it's either going to be cash or it's going to be seller financing. If it's yes, then you're going to provide the lender's information, and then you're going to have the type of loan. Obviously, this is specifying there's a loan contingency, all the costs paid by buyer, typical stuff. But you're not going to have an AAR pre-qual form. So now you're just going to get whatever the lender's pre-qualification form or letter is. This is going to be very interesting to me because I have a feeling that a lot of lenders, especially in Arizona, they somehow have access to the AAR pre-qual form, and they may use that even if it's not an AAR contract. And legally, I don't know how that's handled. Because for all intents and purposes, it's ultimately still the buyer's responsibility to have access to and complete those forms. When necessary, they're the party that's responsible for that. So if their agent is a non-realtor member, I don't know that the lender should be using the AAR pre-qual, but I don't know who's monitoring that. So under this, just understand that if a non-member submits an offer on one of your listings, it very likely will not have an AAR pre-qual form, nor should it. It should have some sort of pre-qualification letter directly from that lender. And we've all seen these. These are just the typical bank letters that sometimes we get instead of an AAR pre-qual anyway. Ours is standard, attached, and incorporated. This one shall be provided within a certain number of days. So just something to keep an eye on. And then is it a pre-qualification? Is it a pre-approval, or is it a fully underwritten pre-approval? I love that that option was added. And obviously something that we should be targeting. That would be our desire, and maybe something to counter back with if it is something other than full underwriting approval or pre-approval, because that means they've actually looked at all of the documents, they've reviewed them, and they've put them generally in their little desktop program to determine if they're going to be a viable buyer. Standard loan application process, same deadline, same timeline, same requirements. Funds necessary to close. Buyer currently has sufficient and available funds for the earnest money deposit, down payment, and any compensation owed to close escrow, and is not relying on any contingent source of funds except as follows. So you don't have to worry about not understanding or not putting it in the additional terms, because right here it is saying, hey, if we are getting funds from something else, we would just put right here where that is. Okay, it's a 401k loan. I'm cashing out one of my stocks. Wherever that's coming from. It's a gift fund. Gifts are coming from mom or dad or whatever that looks like. So now there's just a real easy, quick way to disclose that right here in the contract. You don't have to worry about creating your own clause for that purpose. So again, I like this. I think that this is superior in that regard to the AAR contract. Delivery of funds, that's all the same. Loan changes. Okay, so remember we said, hey, you have to give notice, and it's immediately. Now, again, what does immediately mean? Like the very second you find out, within 1 business day. Again, probably more typical. But this one spells out within 2 days of changing. So again, it's a much more concrete, much more specific timeline for delivering such notice. Then your right to cancel your loan updates. I kind of like this, that it reiterates what ours says, except it's not necessarily on a specific form. But it's just, hey, if the listing agent or the seller requests updates from the lender is going to provide them. So again, kind of a similar process, just different wording there. Seller financing. I'm not going to go into this too much just because I don't know that there's a ton of seller financing options out there. And quite frankly, here is another big change to this contract. Our AAR purchase contracts have multiple seller financing documents, okay? Based on one dwelling, based on multiple dwellings, the non-consumer credit, which is what we see for commercial and land. According to this contract, which you'll see here, you can initiate some of the first steps of that, but you actually will not be facilitating the terms of the loan through the contract. So this is going to tell the seller, hey, seller, you either devise these terms completely of your own accord, you draft your own agreement, and you supply that to the buyer. So you and the buyer are coming to terms completely outside of this transaction with the agents to arrive at your seller financing terms. Or you need to speak to a lawyer and seek independent legal counsel to have that done for you. So it's taking the option away from agents to use the addenda that realtors have access to to help facilitate this. Again, I understand the reasoning behind this. I don't disagree that most agents are probably not equipped to handle financing directives or financing terms, and that's outside our scope. However, there are a few that are very well versed in this, potentially more so than an attorney would be. Yes, I said that, and I think that having those forms there for that purpose, even if it's to give to the seller and tell the seller, hey, here's kind of the draft of what you're going to be expected as far as what's going to be referenced on the note. So go ahead and you complete this with the terms, the interest rate, and the balloon payments, and whatever other things you want to include here. But at least it lets them know what things they should be cognizant of and what they should include in their seller financing agreement. As opposed to not having anything other than, hey, figure it out yourself or talk to an attorney, which realistically is what this section is telling them. And then it goes right into, like I said, that disclosure. Broker should not prepare or advise the parties on the specifics of financing, including whether or not a party is exempt from the law. So it's just kind of taking us out of there entirely. For most of us, probably okay. Like I said, not even something that we're really going to hit on, but for those of you in the audience who might be doing seller financing, it's just something you need to be aware of. Fixtures and personal property. Again, this is going to be very similar to what we already have, if not identical in most cases. I do like that it references /model, line 167 and 168. I think so often we don't accurately describe the conveying property. Ideally, it's not a problem, but the best way to protect your clients is to actually have a model reference in there, whether it's the type and the color, or an actual model number. Those are both very helpful if there's ever litigation or concerns over personal property that's conveying. Right to contract, right to cancel. All of that is identical to the AAR. So again, there's no change in timelines there. The appraisal contingency, if an appraisal will be required prior to close of escrow, the charges fees are agreed as follows. So very similar to line 111 of our purchase contract. If seller is paying the initial fee, this one's a little different, and I think, again, less confusing. So right now in the AAR contract, there's a box to mark. If seller is paying the initial fee, unlikely but possible, it is included in any concession indicated on line 29. So the AAR contract says is or is not, which then people get confused about, well, wait a minute, does that mean I subtract it or I add it to the total concession? So if I'm getting $5,000 in concessions, am I subtracting the $500 appraisal or am I adding the $500 appraisal? So really I'm getting $5,500 in concessions. You see where that can become a little wonky. So this is saying, hey, this is included. So just understand, if you got $5,000, whatever that seller pays for the appraisal is going to be taken from that $5,000. This is not an additional cost to the seller. Again, I kind of like that. I like that it's more clear on what the expectation is. Broker indemnity clauses, nothing abnormal there. Buyer shall pay for any property. I wish that said inspections, plural, during the inspection period. Again, that's how it currently is. And then it goes through the different types. Whatever is of concern to the buyer, they're going to conduct the appropriate inspections. All right, poll 4. Oh no. Sorry, guys. All right, poll 4. True or false? A non-realtor may provide a copy of the buyer advisory to the buyer. True or false? Per the AAR on-site wastewater treatment facility addendum, the seller pays the septic inspection fee. And number 3, on the AAR purchase contract, how many days before close of escrow must the buyer conduct their final walkthrough? All right, there's a few there, so I'll give you a little extra minute. Five seconds. All right, let's see what we got. True or false, a non-realtor may provide a copy of the buyer advisory to the buyer. This is true. So the 46% of you who answered that way, you are correct. The buyer advisory is actually a department document. It is not an AAR document. So you can access it through the Department of Real Estate website, azre.gov. And yes, absolutely, you should be providing that to prospective buyers. True, false. Per the AAR on-site wastewater treatment facility addendum, the seller pays a septic inspection fee. This is true. You will probably discover why I'm asking some of these questions, and really it's to draw your attention to some of the main differences between these contracts. So if you haven't caught on to my polls already, that's kind of my purpose behind the questions I'm asking. On the AAR purchase contract, how many days before close of escrow must the buyer conduct their final walkthrough? We got all sorts of answers. There is no set number of days. That is correct. There is no set number of days, and there is no set number of final walkthroughs. They could do one every day for 5 days leading up to it. That might be a little cumbersome, honestly, to the seller, especially if it's occupied. So bear in mind, you have to take that into consideration as well. But while we most commonly do one 3 days before, the reason for that is because that's in line with when our receipts due for repairs that were agreed upon in the BINSR. So all of that stuff, all of the final steps, pretty much everything is due 3 days prior to close of escrow. That's kind of the magic number. So I think that's where we got it in our heads that that's when the final walkthrough must be done, but there's no designation for that. If you've taken a regular contract boot camp with me in the past, I actually recommend 2 walkthroughs if repairs are made. The first one is at that 3-day mark, because then we can bring the inspector back out to verify that any agreed upon repairs have been made in a satisfactory manner. And then I also recommend doing one the morning of closing, because especially if they hadn't been moved out yet, I've seen some wild things happen to a house right before recordation was about to occur. So I definitely recommend doing those walkthroughs in 2 parts just to make sure that home is in substantially the same condition as it was. All right. And look at this, we're on page 5 of 12. We're getting there. So that was just a continuation again of all of the stuff. Very similarly, although somewhat unknown, buyer shall provide to seller and brokers upon receipt at no cost copies of all inspection reports concerning the property. I'm on lines 197 and 198. This is still argued, and I don't understand. This has been in our AAR purchase contract at least the 3 most recent iterations, probably more than that. So it's been in there for years. That yes, I don't know why these are being withheld or why they're being leveraged or why they are being submitted with the BINSR. Both of these contracts say that you shall send any inspection reports to the seller upon receipt. So as soon as you get them, not with the BINSR, not just when you decide to, not only parts of it that relate to repairs that you're asking for, you send the entire report to the seller when you receive it. More things for a buyer to investigate. Again, these are all very similar. What I do like, again, kind of a change, our AAR purchase contract has a weird sentence that discusses a property being sold in its present physical condition. Now, present physical condition does mean as is, but why we decided to say present physical condition instead of just saying as is beyond me. I'm sure there was a reason for it, but I just think it confuses people. So to this day, we still get offers that reference that the property shall be sold as is. And I sit there and say, but the contract already says that. So why are we creating redundancies in the contract? But this one uses the language that we are more familiar with. So instead of present physical condition, it specifies buyer is purchasing the property in its as is condition. I think that's a point for the non-member contract. I like that it's language that we're more familiar with. Home warranty information, obviously service providers, again, we're not accountable if we make a recommendation. If they do a horrible job, that's not on us. Do your own due diligence as a buyer. Property served by a sewer or septic alternative. Buyer shall have any on-site wastewater treatment facility inspected. The inspection fee shall be paid by buyer, seller, or buyer and seller each pay 50-50. So again, remember with the AAR contract, the default on the on-site wastewater addendum is that the inspection fee will be paid by the seller. There have been arguments about this because everybody was under perhaps the wrongful impression that it was state law. State law says the seller has to coordinate the inspection. Okay, so they have to order the inspection. But the law, the ADEC requirement doesn't actually state outright, although I think that this is arguable, that the seller has to pay for it. So this is opening up the opportunity where that fee, which can be substantial depending on the amount of pumping that needs to occur, can be split up differently. And then it just goes into the ADEC requirement. So same thing within 180 days. But this one, currently ours, well, no, this is still within the timing. Never mind, disregard. So all of this is exactly as we currently see it. So you're set. And they do have, non-members do have a separate addendum for this as well that covers a couple of other things regarding the on-site wastewater. And remember, it's also merged with the well. So the septic and well components are handled on an addendum together for non-members. If this is land, obviously we're going to have some survey stuff. So then there are this, who's ordering it, who's paying for it, the instructions to the surveyor. The termite pest, again, that's paid for by the buyer. We know that they're responsible for all of their inspections. And then just these other reminders. But then we go into the walkthroughs. Buyer and buyer's inspectors shall have reasonable access to conduct walkthroughs of the property within 5 days, that's the default language, or blank days prior to close of escrow. So usually I like specifics, that's cool, but I almost don't want to be in a position where we are limiting our buyer to one walkthrough. So if you are a non-member using this form, I would probably draft some sort of clause in the additional terms that gives them access to conduct any number of walkthroughs to satisfy the buyer without a designated period of time. So that way they're not limited to just this 5 days or 3 days or whatever it is. So if I want to do one at 3 days and I want to do one the day of, my buyer would be able to do that. Now, listing agents, if you are a realtor, do you want to have the buyers doing multiple walkthroughs on the listing? Maybe, but probably not. So this is what I said, where in some cases, hey, you don't need to counter some of this stuff because I think that this is actually beneficial to our seller, assuming they've done what they needed to do, which was make repairs and provide receipts timely, that ultimately this is one of those where, well, hey, if my seller doesn't have to allow multiple walkthroughs, maybe they don't want to do that. And so why would I counter that? I would just go ahead and leave this as
Hey,
is.
Leah.
Yeah,
It,
Melissa.
it does say walkthroughs plural on there, just so you know.
It does, but then it doesn't designate. So they can do walkthroughs, but only within however many days.
Well, but you could do multiple ones within 5 days.
But are they all within that 5-day period? Could I do one within 1 day? Could I do one within 7 days? Could I do one?
Well, within 5 days means 1 to 5, doesn't it?
Well, that's the part that I don't think is super clear on this. So I think when they say within 5 days, so anytime within 0 to 5 days, I can conduct any number of walkthroughs. And then where do we have the reasonable access? I get what you're saying. I think that by putting the date part on it, that's where it starts to get a little confusing.
Understood.
Yeah, I think that's a great point. So yeah, yes. So like, oh, in essence, this should be interpreted as you can do any number of walkthroughs within 0 to 5 days. I think by having that bold 5 days, that's what the expectation is going to be. So again, if nothing else, maybe this is one where just to make it more clear, you remove those deadlines from it. That's a great point. Thank you. All right, making it available, all the same stuff. Going into poll 5. All right, true or false? On the AAR purchase contract, the buyer must provide a copy of the appraisal to the seller if they cancel based on the appraisal contingency. True or false? On the AAR vacant land purchase contract, the default due diligence period is 30 days. And true or false, the AAR purchase contract requires the seller to provide a clue report to the buyer. All right, let's see what we got here. On the AAR purchase contract, the buyer must provide a copy of the appraisal to the seller if they cancel based on the appraisal contingency. That is false. There's actually nothing in the purchase contract that requires them to share that. So ideally, we're kind of hoping that they're being honest, and obviously that is coming from the lender as well. But there's nothing in the black and white that says, hey, buyer, you must provide a copy of this in order to cancel on that contingency.
Hey, we are not seeing the responses if you're seeing.
Oh, let me try this again. Okay, how about now?
Yes, ma'am.
Okay, thank you. True or false? On the AAR vacant land purchase contract, the default due diligence period is 30 days. That is correct. And true or false, the AAR purchase contract requires the seller to provide a clue report to the buyer. That is false. A clue report is a very specific document for the comprehensive loss underwriting exchange unit that covers 5 years for that specific address. What our contract, the MLS, our AAR contract, it says claims history in essence. It's a letter of experience, it's some loss history, it's claims history for a designated period of time. So it's as long as the seller has owned the home or 5 years, whichever is the shorter period of time. So we keep using the word clue, but that's been removed from our contract for quite a while now. So a actual clue report is not required.
I'm upset I got that wrong, Leah.
But now you'll know for next time, right?
Yes.
You saying, Leah, the claims history is?
The claims history, that it's a letter of experience, claims history,
Yep.
and quite honestly, the purchase contract even allows for the seller themselves, if an actual document from an insurance provider is not available, our AAR purchase contract says the seller can disclose themselves if they've made any claims within the last 5 years. But that's all that's required. It's not an actual clue report.
Okay, so we're just debating the term because I call it the clue report, even though it's a claims loss.
Yes, it's
I mean, that's what
there's
we
going
asked
to be
for.
there's a
Yeah.
reason that I'm bringing attention to this, because a clue is something very specific and it's not as easy to obtain. And in many cases, there can be a cost associated with it. So I want to shed light on that difference because of what's in this MLS non-member contract.
Okay, so I'm using it interchangeably. So you're just saying quit using the word clue.
Yeah, knock it off. Knock it off.
Okay, all right.
Don't get a clue. Yeah.
So on
Leah, you
the
said-
so on the poll 5 what was the answer? The answers to one was
Well, shoot, I don't know if I can access the poll again. Hold on a minute. Okay, wait. Number 1, the due diligence. Oh, no, I'm sorry. That's number 2. Number 1, they must provide a copy of the appraisal if they cancel based on the appraisal contingency. That is false.
so it was false. Okay.
That is false. Yep.
And Leah, you were saying that per the AAR contract, it's just since they owned it. It's not, it doesn't have to be 5 years. Because I was taught as a TC that it had to be 5 years. So
Yeah. So when you do a letter of experience or a claims history letter through your insurance provider, they don't give you the duration of the 5-year period. They only give you their experience with you, which may be 1, 2, 3 years, whatever that is. So yes, for as long as they've owned it or up to 5 years. So if they've owned it for 12 years, they don't have to provide 12 years worth of claims history. They only have to provide the last 5.
got it. Okay, thank you.
You bet. Okay. Mary, I knew you were going to ask some more complicated question. I know it says, hey, wait until the end, but I actually want to go ahead and cover this now. 1, so I don't forget, but 2, because I think it's important. If an issue arises with a non-member contract, whether through ambiguity or otherwise, that adversely affects our client in some way, is our client able to make a claim against us as a realtor for essentially allowing the client to use the non-member RPC as opposed to countering with the AAR RPC? In other words, what is a realtor's legal exposure to using these brand new forms? I get where you're coming from, and I understand. I have a unique, well, maybe it's not so unique. I don't think I'm alone in my thought process on this. 1, I would love for the agent to have to prove their knowledge of the AAR contract over the non-member contract. Meaning, if I give you 20 questions about the contract or the 2 contracts, can you answer all of the ones from AAR at 100% accuracy over the non-member? That would be kind of my litmus test. So agents who claim that ultimately they know more, they are familiar with this and that, I don't know how far that claim would go if they can't prove it. Anything that adversely affects our client, and we know this, whether it's this contract or that contract, we're getting named in the lawsuit no matter what, because we're the deep pockets. That's just the way that it works. I've kind of accepted that. I would also say that if this is a concern for realtors and brokers, or agents and brokers, that realistically, anytime a new form is released, until they've had extensive training on it, this is a potential problem. If they're representing buyers for new builds, this is a potential problem. If they've ever worked with an open door offer pad or any similar type of information, this is a problem. So I think that realistically, I'm not an attorney, but I'm thinking realistically, I could fight a pretty arguable case, that it's not, it shouldn't be expected for an agent to know every possible adverse effect that can arise from any contract form, and that ultimately we are required to have the same level of knowledge for any forms that we are working with, regardless of time release or who they're accessible to. And really all we can do is prove that through education. So are they increasing their realtor, in essence, is the realtor increasing their exposure, especially from a legal perspective, by using these brand new forms? Like I said, I think I can make an argument that no, they're definitely not. That ultimately you'd have to prove their level of knowledge on the first ones in order to qualify that this is increasing their exposure. That's my 2 cents for what they're worth.
That's why we pay you the big bucks.
Everybody keeps saying that. I don't think that means what you think it means.
Oh, yes, it does.
All right, moving on. Page 6. So the walkthroughs are continued here. The source of water, well inspection fees, well transfer fees. So all of that is determined right here, as opposed to on separate forms. So that's kind of nice. We're just keeping it all in-house. During the inspection period, buyer shall verify well water rights if deemed material. Again, just a reiteration of what they should be doing. Appraisal contingency, again, that's same timeline, same obligations. Right to cancel, same timeline, same obligations. Seller's right to request. So this is why I had asked that question. For any cancellation based upon this appraisal contingency, buyer shall deliver a copy of the written appraisal to seller upon request by seller. I like that. I like that they have to, not that I'm saying I don't trust them or their lender, but I like that they have to, in essence, prove and show. But it also means that, okay, I can show this to my seller so we could see what transpired potentially with the adjustments, especially on this appraisal. And do we potentially need to consider making adjustments accordingly? I just, like I said, I like having it less ambiguous. And I think that this helps with that and that we're not questioning the validity of their cancellation. A waiver of appraisal contingency, so that's not an additional clause addendum like it is for us now. That's just right here in the contract. Buyer's contingency. This agreement and buyer's ability to obtain financing is contingent upon the sale of a property owned by buyer on or before. I think this is hysterical. So we all talk about how we don't like the on or before language, right? But then what does it say right here? And again, I understand the reasoning for this. Like we don't want to say, hey, it has to occur on this date. That's for the on or before. But I do think that it's kind of funny that the attorneys are like, don't use that language. And then here it is. Subject to any applicable buyer's contingency addendum if attached. Now, remember, as an MLS non-member, you do not have an actual buyer's contingency addendum. So any addendum that you drafted would in essence have to be written by you, or more appropriately, your broker, and attached herein. I am not a fan of the BCA. We know this. I understand why it's so long. I understand all of the stuff involved in that and how do you really account for certain things. That being said, I think as a seller, you are either accepting a contingent buyer or you are not. You do not get the opportunity to micromanage every aspect of that sale. So if they approve of an offer, I don't need to approve of that, as long as they meet their deadlines. I don't think a seller should have the right to cancel because they're speculating that timelines would not be met. And that's really what it is. It's a speculation of inability to perform. It's not factual inability to perform. So for those reasons, I think it's confusing. They also use words like may issue a cure as opposed to shall issue a cure notice. And that just means, okay, so do I have to, or is a failure to meet these dates considered an immediate broach of contingency in essence. It's not a breach of contract, but they failed to fulfill their contingency within that deadline. So can we just cancel right now? I created a clause and I'm happy to share it. If you are not one of my agents, please make sure you run it by your own broker first. That could be used for this purpose. And quite frankly, I would use it now in lieu of using the buyer contingency addendum, especially if I'm representing the buyer, because it just removes a lot of those seller opportunities to get out from under the deal. Like, hey, as long as I sell my home by this date, we're solid, we're good to go, and you're agreeing to that. So if that is of interest, let me know and I will share that with you. The due diligence inspection period. Okay, so 10 days for residential, typical, that's what we've got now, but 20 days for vacant land. So again, if you want more time, just make sure that you're addressing that because that is a change from the AAR contract. Same stuff, right to cancel, 5 days to disapprove, all the normal stuff. Buyer objections and disapproval contingency. So same things regarding notice of objections. So this is especially with what we consider our BINSR, but whatever the buyer inspection requests are going to be, those are going to go in a document. There is one available for that purpose for non-members. And then the timelines for response are the same. So no big changes there. HUD, VA, FHA contingency, same sort of stuff that ultimately, hey, they have special requirements for their appraisals and that's federal law that's going to supersede our state contract. So just bear that in mind. Okay, we referenced the clue report and this is why. So within 5 days after contract acceptance, sellers shall provide a 5-year insurance loss history report clue to buyer. Buyer shall provide notice of disapproval and cancellation within the inspection period or 5 days after receipt of the clue report, whichever is later. So we started off pretty well here. Shall provide a 5-year insurance loss history report to buyer. I think they could do that. But again, what if they haven't owned the home for 5 years? Are they really responsible for obtaining, and the only way to do this is obtain a clue report through like LexisNexis or something similar? Like I said, there's oftentimes a cost for this, and it shows the full 5 years regardless of ownership. I don't know that our seller should have to do that. So that's definitely something that I would counter back with if I received this offer, that no, they'll provide however long they've been in the home. If they've been for more than 5 years, then I can restate 5 years. But in essence, they're just going to provide a letter of experience or claims history from their insurance provider.
So and kind of just to state that if it's an actual clue report, it takes longer than
It
5
does.
days for it to even it's like 5 to 10 business days. So
Yeah, because it comes from a third party. So it's the underwriting exchange unit. So it's not coming directly from like, hey, I can call my USAA rep or my State Farm rep or whoever and say, hey, can you just send me a letterhead that says if I've submitted any claims, and they can get that right through their system and send it to you. But if you do the clue report, yeah, you've got to go through different channels.
yeah.
All right, loan contingency, same obligations, same timeframes there, same ability to issue a cure if something is missed. Marketable title, we do have that in our AAR contract. I like that it's kind of separated out here, so it's its own independent clause. That seller has the ability to deliver good and marketable title as evidenced by a policy of title insurance. The seller financing contingency, I don't love that this is here. I understand that this is a contingency section, so that's why it's being referenced. But in essence, when you've already indicated that we as agents aren't facilitating the seller financing terms, I get that this is then putting the onus on the buyer and seller to arrive at whatever terms they're going to within a designated period of time and to make sure it's satisfactory. I guess I'm just a control freak. So ultimately, I like to have my hands in the pot and make sure that things are being done accordingly and that we're abiding by all of the appropriate timelines. And this just opens that up a little bit more. I guess the moral of the story on that is if you are a non-member who is looking to do a seller financing deal at some point, definitely get with your broker to determine the best course of action, even if it's just a recommendation for a real estate attorney who can help facilitate that or kind of generic documents. I feel like there's other options available there to help. The seller property disclosure contingency. Seller shall disclose in writing to buyer defects in the property known to seller that materially affect the value of the property. I love this part. That cannot be discovered by a reasonable inspection. I understand there is still some ambiguity here. I understand that there's still kind of a vague reference. What is reasonable? However, I hate that our contract says material latent defects. I think that that is so confusing to agents just based on the definition of latent. So this takes it one step further and explains, hey, in essence, you can't start worrying about or backing out for cosmetic reasons, okay? Because you were aware of those things. Those were visible to the naked eye. So this is really things, as far as both disclosure and inspections go, things that would otherwise be discovered and that affect the value, but you would have to conduct some sort of inspection in order to determine that. Okay, so a cracked window, you did not need an inspection for it. Same timeline with 3 days of contract acceptance. They've got 5 days to review or their inspection period. Buyer shall have 5 days after title commitment to review. Disclosures, advertisements, notice to buyer and seller. So all the same stuff. MLS is info only. If you want that fridge, washer, dryer, and hot tub to convey, you better mark it in the purchase contract. That is the same for both of these. The affidavit of disclosure, same timeline, same requirements. Title will facilitate and help with that too. All right, poll 6. This might be our last poll. Okay, I've broken something. Let's try this. Okay, there we go. True, false. On the AAR purchase contract, a buyer may assign the contractor interest without written approval from the seller. True, false. On the AAR purchase contract, a seller must wait until the day after the scheduled close of escrow to cure a buyer for failure to close escrow on time. All right, let's go ahead and end the poll. Oh, this is a close one. On the AAR purchase contract, a buyer may assign the contractor interest without written approval from the seller. That is true. They can do that. And it's just notice. So again, it doesn't require their approval or an addendum to change. That's just what's allowed by state of Arizona.
I
I
can't
can't see the
the,
results.
I can't,
Oh.
yeah.
Oh, thank you. Thank you, guys. Now you can see it. It was close. But true is the answer. They may do so. True, false. On the AAR purchase contract, a seller must wait until the day after scheduled close of escrow to cure a buyer for failure to close on time. The majority of you put true, and it is true, which I absolutely hate. And I have mentioned my hatred of this particular scenario numerous times. Everything in the contract, the argument from AAR Legal Risk Management, the contract authors, fine, is that everything in the purchase contract relates to days, and then performance of certain things is a number of days after, a number of days before. So they wanted to keep it consistent. My argument from day one on this is that close of escrow, the clause for close of escrow on the AAR purchase contract, it does not reference days at all. It references a specific event, and that is loan is funded and is recorded at the county recorder's office. That is when closing occurs. You cannot record after 5 o'clock because the county recorder's office is closed. So my seller should not have to wait until the following day to issue a cure notice when we know that that cannot be done after 5 o'clock. They should be able to they should be able to issue a cure notice at 5:01 p.m. for failure to close and not lose an extra day. I've been arguing this forever. I've been shut down forever. But God bless Jesse, because you'll see something here that I absolutely love in this contract. It is probably my most favorite addition that I saw to these forms. So changes to disclosures, same stuff. If you deliver notice of any updates to your disclosures, buyer has 5 days. Failure to pay, all of that stuff, closing funds, FERPTA, known material facts. I do like, and I reference this, seller does not have an obligation to inspect the property for the buyer's benefit. So just bear that in mind. I still see so many Binzers that come through where one of the requests from the buyer is seller to inspect the HVAC unit and correct any corresponding repairs, or seller to further inspect the roof and make any repairs the roofer deems important. No, 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 no. That is not the seller's responsibility. The buyer needed to contact, and I get it, they probably don't want to pay for additional inspections, but the buyer is responsible for asking for very specific repairs. So you can't ask the seller to evaluate, investigate, or inspect any items. You, as the buyer, need to pay to have any roofer come out and evaluate and give you then a bid for repairs or a report that indicates what needs to be done. Same for HVAC units, hot water heaters, any of those types of things, especially major systems in the house. So please just be aware of that, but I do like that it spells it out here, I think a little more clearly, but so they're aware. Seller shall deliver to buyer a fully completed. So I referenced, hey, we don't have like the lead-based paint disclosure and addendum that we have compacted for the purposes of AAR use, but it shows you or tells you right where to go here. Seller shall deliver to buyer a fully completed federal lead-based paint disclosure and protect your family from lead in your home pamphlet. So it's saying, hey, go and look for this. You can just Google this. You can actually pull down this disclosure and packet, and then you can go ahead and you can have the parties sign and acknowledge. Originally, I had misread this, so I'm glad that I reread it last night. I didn't recall seeing a verification of funds clause. I think maybe I was looking up in the initial pages of where money was coming from and the financing components, etc. And so I didn't think that there was a requirement for proof of funds. I'm happy to report for those of you that this was a concern for, it is. And it's just right here. If a cash transaction, buyer shall attach verification of readily available funds to close escrow. Easy peasy. Wire fraud, again, right there, the warning is in there, no separate advisory needed. Seller warranties, same stuff that we see on the AAR purchase contract, same with buyer warranties and warranties that survive closing. The cure period operates exactly the same way. The timing of such cures are exactly the same way. The references to non-compliance are exactly the same way. If cured for failure to close, same thing, close of escrow shall occur on the next business day that both are open if that cure period expires. Then we go into the breaching stuff. Ultimately, the same general language. There's a couple of changes. If we go down here, specifically to ADR and mediation. So right now, Realtor members have access to mediation and arbitration through the board. So through AAR. Obviously, you won't have this if you're a non-member. And even the buyers and sellers, there are helpful tools and resources available to them if their agent is a Realtor member. And again, that's not going to be what happens here. So they're just going to be submitted through typical mediation processes that are handled by the state of Arizona and our courts. So maybe not a huge deal, but just something to be aware of. Ideally, if you get rid of the necessity for mediation or arbitration or litigation for earnest money disputes, you'll get rid of 90% of the problems that would ultimately have to go to mediation anyway. There will be others, but that'll be a big one. Assignment, I like that this is spelled out. So buyer may not sell, assign, or transfer buyer's rights or obligations under this contract or any interest herein unless otherwise negotiated. So again, if you're a non-member and you're submitting this offer and your buyer wants to assign, you may wish to remove that clause. But I think for most of us, we're like, excellent, we agree. You shouldn't be able to assign without permission. You shouldn't be able to hand your contract rights over to another buyer without an addendum and permission from the seller. So just an addition, like I said, that I liked. I also like this licensee disclosure of interest. I think sometimes, not intentionally, you just forget if you are going to be a principal in a transaction or you're related to a principal in a transaction, you forget to make that necessary disclosure to make the other party aware of that relationship. So here it makes it easy for you and you just have a box that you need to mark to disclose that. Only if it applies, obviously. All the risk of loss stuff, still the same percentage, same requirements. Calculation of days. Okay, so I told you that I love this one because it specifies if a party fails to close escrow on the closing date by 5 p.m., the non-breaching party may issue a cure notice after 5 o'clock. I love it. I think that that's something that we should include in all of our contracts, but here it is in, excuse me, here it is in black and white.
Leah, can't we do that anyways?
Yeah. Well,
I mean,
you could write it into your contracts, absolutely, but that's not the pre-written language. So as it currently well, that's not the current interpretation from the legal team for AAR. So they will tell you, unless you have changed your purchase contract to reflect when closing is curable, then you cannot issue a cure notice until the day after closing was scheduled to occur.
hmm,
Yep,
It's
that was my
interesting.
thought on it. Same stuff. Copying the counterpart, subsequent offers, notices, same delivery methods. This one has not changed. Delivery via text is not valid, so bear that in mind. Your notices need to be hand delivered, faxed, sent via email, or sent by an overnight courier service. And then cancellation rights, release of brokers, all that stuff again. Same mumbo jumbo. Additional terms and conditions. This actually extends. I just thought I would save a little space. So you have space should you need to put additional terms and conditions in there. And then this is a more typical legal signature page. Your dates and then just their signatures and then acceptance or counter offers. So they have the multiple spots here where the seller can accept, counter, or reject. And if you are using, if you are receiving one form, you have the right to use the counter addendum for your own whatever your membership / subscription is, and vice versa. So if I'm receiving one of these, I'm countering I'm either accepting it or rejecting it, which is fine. But if I'm countering, then I'm countering on the AAR counteroffer form. If I am a non-member and I receive an AAR purchase contract and I'm countering, then I'm countering on my non-member counter form. It may have been Sally Ireland. Somebody brought up the misnumeration potential here. So in essence, if a non-member submits a counter offer, that's a non-member counter offer 1. Would the next counter offer on an AAR form then be AAR counter offer 1 or just counter offer 2? I am going to tell you, for the sake of everyone involved, please just go numerically and sequentially. So I don't care who generated it. If you got one, then that one's 1. The next one to go is number 2 and 3 and so forth. Otherwise, when we start referring to counteroffers, it's going to get a little more sketchy than it needs to.
Excuse me, Leah, could you scroll back up to that last page?
Sure.
Okay, where it says, oh, one more page up, sorry.
Oh, I'm sorry. Okay.
It says about the compensation there. It says something about delivered in a separate form, but I thought it was part of the agreement, or am I reading that incorrectly?
So you'll still have your, in this case, I think it's related to your, either your ER, which would be unusual to send to a title company. I guess they could ask, but typically they're just asking for your signed commission instructions or your buyer broker agreement. I will tell you that the majority of title companies, for kind of a checks and balances, they have been requesting a copy of your buyer broker agreements.
Oh, okay. All right.
You're welcome. Fast reader. Okay, any other questions before I go into just a couple of summary highlight stuff? Okay. There may be a few others, but I tried to write out as I was going some of the main differences between the forms. So the earnest money due within 2 business days, okay? I should have like a little star because I like that one. Buyer broker compensation is within the PC, not a
Hey,
separate
Leah,
form. Oh,
the
yeah.
screen just went blank. So we're not seeing your screen right now.
Well,
I
okay, let me
can
try.
see your screen.
I'm able to see it.
Oh, really?
Yeah.
Yeah, well, I can see it.
Interesting. Okay.
I got nothing. Okay, well, good. I'm glad it's not on my end because I don't know how to fix it if it was. Okay. And like I said, Lisa, these are the last 2 slides, and I'll send out this slide deck so you'll be able to see all this stuff anyway. Buyer broker compensation within the PC, not a separate form. Okay, so you don't have to submit an SCA because you don't have access to an SCA if you're using this contract. Failure to close is curable at 5:01 p.m. the day of close of escrow. Earnest money disputes go to mediation as opposed to being handled by escrow title. Remember, that was the one where I was like, probably not a fan of that one, and something that I would want to consider countering. HOA fees or terms within the PC, not a separate addendum. No standard pre-qualification. It can be any letter from a bank. Specify seller financing shall be handled by a seller and or attorney. So there's no seller financing addenda to accompany this. Buyer contingency is the clause within the PC, not a separate addendum, but you probably should look at having at least a clause to incorporate to better spell out the timeframes for performance there. Assignments require written approval. Same contract for both residential and vacant land. Vacant land has a 20-day inspection period as default as opposed to 30 on AAR. Requires a clue report instead of claims history. Like I said, that's another one that if I were to receive this offer, I would counter back. This is just a general note. It has nothing to do with this contract itself. There's no residential lease or commercial forms available, just a heads up. So if you joined the non-member option and you intend to do residential leases or use AAR forms for commercial purposes, you will have to rejoin AAR and be a Realtor member to have access to those. There's only one buyer broker agreement. So with AAR, we have the two, right? We have the agreement to show and then the exclusive. This one just has one that you can set the different parameters within that same document. And then the combined septic well addendum. So the way that this is written, and I apologize, I don't think I hit on this. There's no 1% seller paid repair fee. So on the AAR on-site wastewater addendum, for any of you who have worked with septic, the default language, and of course it's modifiable, but the default language is that if there are any issues with the septic system, the seller shall pay up to 1% of the purchase price to make the repairs to the system. That language does not exist on this particular addendum. So if that is something that you, representing a buyer, would want to make sure is incorporated, just make sure that you add that to your additional terms. Just a couple of these, and again, definitely chat with your brokers on others, and I assume we will come up with more as time goes. This is just kind of first glance things that you may want to consider. Incorporate the AAR buyer contingency form or counter with a simpler contingency clause that still has specific deadlines for performance. Okay, so especially if I'm representing the seller, I don't want them to have an open-ended any property at any point that they own. Only by this, I might have other, like if it's not already listed, when it's going to be listed, things like that. There are things I'd want to control outside of just, oh, by this date. The big E, contrary to line 64 to 70 of, and I'll have to change that now, non-member purchase contract, in the event of an earnest funds dispute, the escrow company in its sole discretion shall release the earnest funds in accordance with the terms of the contract. So that's, for me, that's probably going to be the biggest one that I want to be sure that I'm countering with to have upheld. But again, talk it out with your clients and your broker. Buyer agrees that the inability to obtain loan approval due to the failure to lock the interest rate and points and or failure to have the funds necessary to obtain loan approval conditions without conditions, yes, prior to doc approval without conditions and close this transaction is not an unfulfilled loan contingency. So right now, the AAR purchase contract specifies that, hey, if you failed to lock your interest rate and you no longer, especially if your lender put MKT or market rate or didn't put a percentage rate on your pre-qual and LSUs, and you failed to lock your rate to get approved for that loan, that is not an unfulfilled loan contingency. So that means that if you the buyer, cancel because you no longer qualify or you can't afford the loan because of an increase in rates, that you shouldn't get your earnest money back because that's on you for not performing accordingly. But that clause, that requirement doesn't exist on the non-member contract. So again, as a seller, if I represent the seller, I would probably want to counter that back in so that they understand if the loan denial is based on failure to lock interest rate, or in essence, an increase in payment for that reason, you're not getting your earnest money back. That's not an unfulfilled loan contingency. Any incorrect or undisclosed HOA fees in the MLS shall be paid by the buyer, seller, or split. Again, depending on who you represent, that may or may not be a concern, but just something for consideration that's missing from this particular contract. And again, the seller shall provide to buyer a 5-year insurance claims history or a claims history for the length of time the seller has owned the property, if less than 5 years, and that's as opposed to a clue report. So just a few, like I said, that I wanted to have accessible to you. I think that the response to this new contract was overwhelmingly negative, and I really think that that came from a place of some legitimate concern. Like Mary had mentioned, are we opening ourselves up to legal liability? And I think that that was the biggest question amongst many brokers. I will say, at least based on our conversations with attorneys and our E&O carriers, things of that sort, overall, we're not hearing that it's any bigger concern, like I said, than you mistype a clause or you help represent them on a new build or a lease or something with which you're not familiar. I think all of those run in essence the same amount of risk, and on a ratio basis for the number of non-MLS or non-members with MLS access, I think realistically you're probably looking at about the same. So hopefully this has dispelled some of your concerns and fears over this new form. At least you've seen it. Like I said, you'll have access to all of the documents for non-member just so you can see them. You can't access them for the sake of completing them if you're a realtor, but at least you'll be able to see the forms and familiarize yourselves with them. Other questions?
Good info.
Excellent. Well, I will, as soon as this finishes recording and doing its thing, anyone who registered today, I will send all of this out to you. If you do have questions, just reach out and let me know. I'm happy to answer some of them. If you're not one of mine, it might be, hey, chat with your broker about this because I won't assume liability for you. But overall, I'm happy to help when I can.
Thanks, Leah. See you tomorrow.
My pleasure. Have a good one, everybody.